Hello, hi Rajiv ji, Kamal here from merasangeet.com and a warm welcome to you on our show Chat in Chat.
Hi Kamalji, Pranam, how are you?
I'm very well, thank you Rajiv ji. How about you?
I am very well, thank you.
So Rajiv ji, before we take up the query sent in here by our listeners this week as well, just wanted to know in case there's anything latest that you would like to update our listeners about the immigration reforms bill and President Obama's action plan.
Well, something very interesting happened. I hope we have a few minutes to talk about this. I can actually discuss the decision for 3 hours if I wanted to, because there are so many legal nuances. But I will probably do about 5-6 minute presentation. Is that okay?
Absolutely fine, Rajiv ji.
All right. So what happened yesterday was a judge in Pittsburgh, Pennsylvania, said that Obama's immigration plan, as far as it applies to illegal or undocumented people, is unconstitutional. Okay. Does that affect the legal part? Probably not. So if we, because this is a question that has been coming up quite frequently, and I've answered this question 17 times since this morning, is the legal immigration plan going to suffer? And the answer is probably not, but we don't yet know. Okay. And the second part was, how about the H-4B employment authorization regulations? Are they going to suffer? And the answer is no. The EAD for H-4 people is not a part of this decision. That is still on track. Let's see how that goes. Now, what happened in this case? The case is United States of America versus Leonardo Juarez-Escobar. It's a case out of Pittsburgh, United States District Court for the Western District of Pennsylvania. The judge actually has a history that points to actions that are quite aggressive from the bench. I have an article on this both on our website, in my blogs, as well as on our LinkedIn site, and I pointed out what the newspapers have said about the judge's earlier issues. I mean, this judge in 2008 was actually removed from a case by the Court of Appeals. That never happens. There has to be something. I haven't investigated the facts myself, but it looks like the judge is prone to very strong action. And he's proved it in this case. I'm very surprised. It appears that this case should not have involved the judge having to reach constitutionality of President Obama's plan, but the judge does make some couple of good legal arguments. The rest of it is still open. So where it leaves us is this: we have a court that says, look, President Obama's actions are unconstitutional. Now the question is, does this have application for the whole country or only for the jurisdiction of that judge? Because that judge is only for a particular area. He's not for the whole country. And the answer is, because it talks about constitutionality of an action, I think the presidency has a problem, because as long as this ruling stays the way it is, they would have trouble implementing this ruling. Okay. Now what happens is, interestingly, if something had not been said about the constitutionality of the presidential action, and just there was a local observation made about USCIS, that would not have national impact, because USCIS considers itself bound by a particular decision only in the jurisdiction of that court. Okay. So, but when we talk about the president and a judge saying the president's action or purported actions are unconstitutional, it probably has national impact. So I think this case is going to get reversed in appeal, simply on a procedural ground that the judge did not need to reach the constitutionality of executive action in a case that had no connection with it. I think that is the weakest link in this decision, that the judge really did not need to go this far. Anyhow, we'll see what happens. It will turn out to be an interesting situation. I have reviewed the decision. It's a 38-page decision. I've reviewed it, And other than a couple of places, I find there's a lot of ground or a lot of reasons this case should in fact be reversed. Um, Although I don't know if Obama administration has so far planned to file an appeal. I think they'll have to. They have no choice. So on the undocumented relief side, we have a problem. On the legal immigration side, there are no observations, of course, from the judge. So whatever plans have been made on the legal immigration side should be okay unless the administration backs off the entire immigration action. Do you have any
Right.
questions, or is that clear enough?
Absolutely, Rajivji. I'm sure a lot of our listeners here, in case they do have any queries on the same, they would revert back. They can write into us at kamal@mirasangeet.com or visit your website, that's immigration.com. Meanwhile, Rajivji, we do have some queries sent in by our listeners here.
Yes, ma'am.
Yeah. So the first one here says, uh, he is in the United States. He's been here for the last 20 plus years. He's a citizen of the United States and he now wants to sponsor his brother. So the question is, how could he do that? Should he apply for a student visa for his brother so that his brother comes over and goes in for some college degree or some course here in the United States? Or should he apply for some other visa?
The strongest visas for any professional person to come to the United States are H1 or L1 in case of countries like Australia, where we have special visas, E3, countries like Canada, TN, Mexico, TN. H1, L1 are universally applicable to all countries. These are all professional visas based upon the person being a professional and getting offered a job in their profession. Now, student visas are weak only to the extent that they are basically dependent upon the discretion of the consulate. If your brother goes to apply for a student visa, there's no guarantee that he will be given the visa. Okay? If you applied for his green card, under the current body of laws, you can apply for your brother or your sister, but it takes 13, 14, 15 years to get the green card. So keep that in mind. Of course, there is an option of making an investment, $500,000 or $1 million, depending upon what options you take. If you come from a country where there is a treaty of trade and investment, like Pakistan has a treaty of trade and investment, many of the European countries do, the Canada does. So those people come on E2 or E1 visas. These are the options that typical people have, other than student visa or a professional visa.
All right. The second query here, Rajivji, is from another listener who says, my wife came to the United States on H-4 initially and applied for H-1B. She has got RFE asking for more project details. She got one job offer meanwhile, and her employer replied for RFE, also filed separate amendment petition with new job offer details. So he says, we've got approval for H-1B without the I-94 details. Shall we expect I-94 once the amendment process is approved, or what else can be done?
Okay, the facts here are insufficient. I do not know if the same employer applied for the amendment. I think what has happened is, and I'm making a guess here, if my guess is incorrect, then my answer is incorrect. My guess is that they applied for an H1 for Project X. While the case was pending, Project X went away and Project Y came along. So the same employer, while the application for H1 for Project X was pending, filed an amendment to reflect that while this case was pending, they had gone ahead and started on the Project Y, or they want to change the H1 to Project Y. And the answer is, these days, USCIS does not allow that easily as a change of status or within the United States. So typically, if they allow you the amendment, it will also require your wife to go outside USA for visa stamping. It is unlikely that she will get her H1 within the United States.
Okay. Finally, Rajivji, I must convey a message to you from one of our listeners who's posted on our Facebook page. She says, "Thank you, Mera Sangeet staff, Mr. Rajiv S. Khanna and Kamal for the show. I recently got a lot of help from this show, and I appreciate it from the bottom of my heart. I live in a town where we have only one immigration lawyer, and then too, she is not as experienced as and good as Mr. Rajiv S. Khanna. To get advice twice from a lawyer as good as him, free of cost, is truly a blessing and a ray of hope um, in sometimes very complicated world of United States immigration."
Thank you so much, Kamalji. I'm always very appreciative of people's feedback, and I truly, from the bottom of my heart, sincerely appreciate the opportunity to be able to help people without it being an expense to me. I mean, a lot of people have to go out and do affirmative work, and here we are sitting in our office. We can be helping people with just a few words. It's truly a very blessed situation. I appreciate it. Thank you very much.
And Rajivji, we really thank you again for all your time, that you spend with us on Chat and Chai, helping all our listeners. It's really nice to have you grace our show every Monday on Chat and Chai.
Ma'am, I appreciate the opportunity. Thank you so much.
Thank you so much, Rajivji. Have a good day ahead.
You too. Bye bye.
Bye bye.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.